યસ તમારે
હાલના કામે સાહેબ અમને ચાકલિયા પોલીસ સ્ટેશનના ગુનામાં 29/4/23 થી અટક કરેલા છે. સદર ગુનામાં સાહેબ અમારી સામેના આક્ષેપ જોવામાં આવે તો દ્રોહી પ્રતિબંધક મુદ્દામાલ મંગાવવાનો અમારી સામે આક્ષેપ છે. વધુમાં સાહેબ આ કામે અન્ય 3 આરોપીઓને 23/23, 273/23, 246/23 થી જામીન મુક્ત કરેલા છે. ફરિયાદમાં કહેવાતો કોઈ પણ ગુનો અમે સાહેબ કરેલ નથી. ફરિયાદમાં અમારું નામ નથી સાહેબ. હાલના સાહેબ 346/23 થી
હજી તો હમણાં પકડાના છો તમે? હજી તો હમણાં પકડાના. 22 થી ક્યાં ગયા હતા?
અમે સાહેબ જ્યુડિશિયલ કસ્ટડીમાં જ હતા. ફરિયાદમાં અમારું નામ નથી. અમે જેતપુર મુકામે જ્યુડિશિયલ કસ્ટડીમાં હતા સાહેબ. ત્યાંથી અમને ટ્રાન્સફર વોરંટથી લાવવામાં આવ્યા
છે. એવું છે? યસ.
અગાઉ સાહેબ આના અરજદારે જામીન અરજી કરી હતી આગોતરા, જે નામદાર કોર્ટે નામંજૂર કરેલી છે. એનો નંબર છે સાહેબ 148/2000.
હા, તમને ખબર જ હતી ગુનો તમારી સામે થયેલો જ છે.
અરે મેન્શન બી નથી કર્યું. એ છૂટેલાના બધા નંબરો લખ્યા છે, આગોતરાના નથી લખ્યા.
મેન્શન કરો કાલે તમે.
બીજી કોઈનું કામ બતાવી રહ્યું છે.
શેમાં?
એટલે આજ મેં આધારી છે સાહેબ.
શું છે?
પેલી ઇન્સ્યોરન્સ પિટિશન છે ને, એ
ઇન્સોલ્વન્સી
28/17 છે. સાહેબ થોડું કોર્ટનું કામ એડજસ્ટ કરીને આવું સાહેબ.
તમારા કંઈક ઓફિસર આવવાના હતા એમાં?
સાહેબ એ ના આવ્યા સાહેબ. હવે એ ના આવ્યા.
કેમ?
કોણ જાણે સાહેબ.
એનાટું તો એક્ઝામ કરી દીધું.
હા સાહેબ, હવે મારા માટે ભાર નાખી દીધો. મને જે કહેવાનું આજે આપી દઈશ સાહેબ.
છે એનું પેલી
જજમેન્ટ લેવી સાહેબ. હું થોડી પતાવી ના
પતાવી ના.
એક નંબર બોલો છે. 1/23 છે.
આપણે બોલતા હોય તો કોક ને કહેવાય ને. શું લખી લ્યો છો? તમને તો કેવું પડે કે તમારો કેસ છે. ભાઈ આમ ગોતો પાછી ઓલાને પૂછો, શર્માને બોલાવો, તરુણ ને કેમ. ચાલો હાલો પછી જો કઈ છે. કેટલો લાગે? અચ્છા, 10 વર્ષનો ડિલે. આ ડિલે છે તમારી?
એમની છે સાહેબ.
હા,
કબડિયાભાઈની છે સાહેબ. 2005 ડીલે સાહેબ.
વેકેશન પછી
મેં જવાબ આપી દીધો સાહેબ.
તમારો જવાબ આવી ગયો છે?
મેં આપી દીધો.
તો વેકેશન પછી
the official receiver have taken the possession has already stated the action are subject to the final proceeding under the Securities Act. Therefore, the petitioner bank or any financial institution like names which are exempted under Section 8 of the Provincial Act did not fall in queue for weight, etc. Now, this application is given before the trial court. Along with that, they have produced certain documents also. Now, Honorable Court would be pleased to note that Exhibit 191, along with that, certain documents are produced. Now, this application is made before the trial court on 18-10-2012. Sorry, 25-2-2013. Affidavit of 18-10-2013. Now, before this, they already issued, proceeded before the DRT. And DRT માં જે અરજી કરી છે, that application is also produced in Annexure F on 7-2-2012. So before giving this application, they have already approached the DRT. Now you have please note that DRT proceedings they have produced before this trial court Annexure F, and I am referring to the paragraph 5.10, 5.9. The appellant bank also issued notice on 5-11-2011 dispatched through registered post AD on 7-11-2011 through its advocate to all about defendants recalling the account and demanding the repayment of the amount. So it was not a notice under Securities Act up to 2011. You may appreciate this. Up to 2011, no notice under the Securities Act was given. Only recalling the account was given on 5-11-2011. Now, then you have please note that the important is paragraph.
Actually, no repetition, only the judgments.
Then what I say is, Securities Act notice was never issued.
That you have already submitted earlier.
Therefore, my submission to Honorable Court.
Today only
I understand, but I am just referring to the fact. Now,
facts not
Securities Act, this is not my proceeding under the Securities Act. Any action taken by the bank, I have not challenged that action. They have not taken action at the time of filing this insolvency proceedings. And it is a matter of record that even after filing this DRT proceedings, they have issued the notice under Section 32. Today too, it is not solved. So unilaterally, you may issue one notice, but compliance of the statutory provision is not there. And therefore, your office note that if we refer to Section 13, to your office note that. Where any borrower who is under liability to a secured creditor under a security agreement makes any default in repayment of the secured debt or any installment thereof, his account in respect of such debt is classified by the secured creditor as non-performing asset, on which
In this matter, we are only concerned with by the exhibit 191, the application was allowed. By recording or by concluding that, one, BOB
Section
is a secure creditor and the trial court do not have jurisdiction to decide the issue under SURFACE Act. Secondly, by referring to section 8, insolvency petition is not maintainable and thereby that application came to be allowed. An interim order, whatever was passed, that has been set aside.
therefore,
So only issue before this is only on 2 points, whether insolvency petition was maintainable before the court or not. And secondly, when there is SURFACE Act, whether the court can decide the insolvency petition or not.
no, it's not there. As far as section 8 is concerned, I have argued out.
Yes.
So I will not repeat that. There is always a distinction of exemption and bar. Section 8 says that the insolvency petitions cannot be filed against the registered corporation, etc. So ultimately, it's not that the declaration that particular corporation is insolvent, that cannot be filed under section 8. Because it's not that, section 8 does not debar the debtor to file insolvency proceedings. Bank is one of the creditors. Maybe proper party, maybe necessary party, but ultimately, it's not that. All those who are creditors will be before the court. That doesn't mean that it is a petition against the bank. It is a petition by the debtor for declaration of this. And therefore, section 8 would not be attracted. And therefore, I have already relied upon the judgment also. That is before the honorable court. Now, as far as the Securities Act is concerned, first of all, it's not that. If we refer to section 34 firstly, when it would be there. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of action taken or to be taken in pursuance of the power conferred by under this act for the recovery, debt tribunal, etc. Now, first of all, no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under this act. Now, therefore, it's not that they have filed a proceedings before the DIT. Now, DIT proceedings against that we have not before the civil court. The important aspect is this. We are before the honorable court by virtue of our status that we have become insolvent. So my application is not maintainable. That is not the case. The issue is whether the bank, being a secured creditor, can be one of the parties or claimant in this petition or not. That is the issue. So my submission to the honorable court is the trial court has misdirected itself. Section 34 would never come into picture because it had nothing to do with the insolvency proceedings. And you may also appreciate this, that section 34 in respect of any matter which a debt recovery tribunal or other appellate tribunal is empowered by under this act. So suppose your is not debt and notice under the Securities Act is given and any action is taken by the bank, then that action cannot be challenged before the civil court. It is not the case here. And therefore, it's not that it is a misconception. of the trial court about the attraction of section 34. And in this case, your office not there. What I was pointing out is this, that the bank has never, on the contrary, if honorable court considers their own application, when this petition before DIT was filed, you may also consider this. Before DIT, they have filed proceedings. What they have stated in this paragraph 5.12. Now, this will be very important. Subsequently, as per the guidelines of the Reserve Bank of India, the relevant cash credit account has been classified as non-performing asset in the books of account as on 31/1/2011. Thereafter, the authorized officer of the applicant issued notice under section 13(2) of the Act, and on 8/2012 for repayment of the amount of rupees 2 crore, etc. The defendant did not make any payment of the state till the amount. Now, important line is this: the applicant reserved his right to go ahead with further proceedings, measures under the Surface Act 2002, if the same deemed necessary. So, till the filing of the DRT proceeding, they have not initiated any proceeding under the Securities Act. It is their own case. So, my submission to the Honorable Court is, unless and until they initiate the proceeding, how the civil court can say that section 34 bar is there? They have reserved their right as per their own case. So, my submission to the Honorable Court is, all the judgments which my learned friend has produced, first of all, 2011 Kerala, in this case also it's not that section 34 is attracted, then civil court has no jurisdiction. But if you do not take any action under the Surface Act, and now you come to the civil court, insolvency court, and say that yes, I have issued one notice, therefore section 34 would be there, that would not be the correct position, legal position. And therefore my submission to the Honorable Court is, this judgment would not be attracted. 2011 Kerala, page 1. Then second judgment, AIR 2001 Allahabad, page 289. Provincial Insolvency Act, section 8. Insolvency proceedings, exemption from Punjab National Bank, a registered government company under section 617 of the Companies Act, exempted from insolvency proceedings. The writ petition is directed against the order dated 7/9/2000, passed by the respondent number 2, rejecting the insolvency petition filed by the petitioner, and the order of the appellate court on 8/3/2001 after affirming the said order in the appeal. Briefly stated, the facts are that Punjab National Bank branch Station Road, Muradabad, respondent number 3, in short, filed suit number 77717 of 1991 for recovery of the amount against the petitioner, as well as Mr. International and others. The suit was decreed on 10 Banu for rupees 20 lakhs and owed amount. The petitioner filed an insolvency petition before second respondent number 2 for declaring insolvent with allegation that rupees so and so is due to Punjab National Bank. He has 1.17 share in those houses situated in Sehora town, district Binjore, the value which is hardly rupees 1,000 and the bearing close, etc. The bank raised an objection that insolvency petition is not maintainable against the bank in view of section 8 of the Provincial Insolvency Act 1920, which read as under. Now, further paragraph. After the enforcement of the Banking Companies Act, banking companies, including the foreign companies registered under the Companies Act 19, so nationalized bank and more 51%, etc. Punjab National Bank is in the first column, and the second column it has been referred to as the Punjab National Bank section, etc. In view of the aforesaid provision, lo, the Punjab National Bank is a government company. The view taken by the court below that the bank is a registered company and therefore it is exempted from insolvency proceedings does not suffer from any illegality. So, it's not that once you are exempted from Punjab National Bank, a company, registered company, etc., exempted from. Now, therefore, my submission to Honorable Court is this judgment, wherein Section 8 is considered, no doubt. But my submission to the Honorable Court is that this case, only one creditor and one debtor.
Yes.
After decree is passed, he has filed insolvency proceedings. Now that insolvency proceedings, your office not there, relating to decretal amount only. So the view taken in this text may be there. But still I say, Section 8 is a very important, it exempts, means if you refer to Section 8, your office, very important section, if you read between the lines, your office. No insolvency petition shall be presented against which what? No relief can be obtained against a person. So, it's not that any corporation or against any association or company registered under any enactment for the time being. So, Section 8 has given an exemption. Exemption means you cannot file a proceedings against the registered corporation. That I may be declared insolvent against particular person. So that petition would not be maintained. But if I file a petition as a debtor that I am insolvent, including so many creditors, one of the creditors is Bank of Baroda. That doesn't mean that my petition is not maintained. I have not asked any relief against the bank. My prayer is not against the bank. My prayer is only that I may be declared an insolvent. So Section 8 is very important. If I ask the relief in view of some decree is passed only against that decretal amount, then it may be so.
Then why have you joined only the bank?
Not all creditors are there. You may appreciate this is very important.
Bill memo is only against the bank.
No. I would say only on the contrary this way. There are numbers of creditors. I have entered the list also. Exhibit Schedule 1. All creditors are there. All creditors are. I have given a list, complete list.
What about your course title?
Course title are this. दाहोद मेरे पास प्रिंसिपल सीनियर सिविल जज साहब की कोर्ट में नादारी હતી so and so. Now that is under section
The court has passed only the name order to the effect that to delete the name of Bank of Baroda.
correct. Now therefore ultimately what will happen?
So your submission is that you are not claiming relief against the bank.
Only against the bank. I am not claiming relief against any creditor. I am asking the honorable court that I may be declared insolvent.
So then if your only relief is to be declared as an insolvent, then, and you are not claiming any relief against the bank or any other person,
No,
then why are they joined as a party?
because your Honor is not there. Now, your Honor is correct. What would be the insolvency proceedings? It is a judgment in RAM. It is not personal. Suppose your Honor is not there, the consequences if I am declared insolvent, your Honor, I have to give the list of the creditors. Even if I do not give, the Honorable Court will issue the public notice. So every proceeding under the insolvency is a judgment in RAM.
So then
So
there
suppose
is,
I have not disclosed
Hmm.
that the bank is a creditor. Assuming that. I have not disclosed it. Honorable Court will issue the public notice and issue the public notice. They may approach the court. But that doesn't mean that I have asked the relief against any person. And therefore, your is not that if Honorable Court considers I have been given right as a debtor, your Honor. And therefore, my application is very important.
yes, we will not go in there. We will go only for this submission only.
No, I understand. But therefore, your Honor, is not that. If the bank is deleted, your Honor,
Hmm.
then what would be the position? Now, you all may also appreciate this. We have to refer to section 47. Simple, they are secure creditor. That doesn't mean automation is provided. And therefore, section 47. You all may also appreciate this. Of the insolvency. Section 47 and section 47(2). Where a secure creditor releases his security, he may prove for the balance due to him after deducting the net amount realized. Now, when a secure creditor relinquishes his security for the general benefit of the creditors, he may prove for his whole debt. Now we have made an allegation against the bank that we have informed the bank that you take the action because you are secure creditor, and the bank has not taken any action. And therefore we say that this conduct of the bank, whether the bank has ceased to be a secure creditor by this conduct, that is also made an
That is not a point. How can by way of conduct, when you are saying that you are a debtor of the bank, how can you say that the bank has given up their right
under section 47.
as a secure creditor?
47.
There cannot be, it cannot be, unless you pay the amount,
That is
or that amount is realized by the bank by whatever means that are available under the law. Their right cannot be said to have been extinguished.
No, I do not say. I do not say that Insolvency Act says, section 47. You may appreciate the secure creditor.
Yes, secure creditor.
Where a secure creditor releases his security, he may prove for the balance due to him after deducting the net amount realized.
So net
Then
amount,
two, where a secure creditor relinquishes his security. None of it is not that. Relinquishment doesn't mean that in writing.
see, he has to relinquish his security,
Huh? Correct. But
but he would relinquish the security only after realizing his debt.
no.
He would not give up his right. No, there are many secure creditors
No.
for this person, and therefore
Your may, therefore we say that the bank being a secure creditor, he is also required to be active for the security. This attitude,
his
contact,
attitude we will consider afterward.
then therefore I say you may consider later on. I do not say no to it.
That we will not consider right now. He is a secure creditor. As per your say,
I do, no,
Now,
I have
without-
not said that way.
Without realizing any amount from you,
So there is a provision for this.
and there is nothing, you have not paid anything to
I do
anyone.
not say no to it.
Then
But the question is whether he has remained a secured creditor.
he has remained. How can you say that he has not remained a secure creditor?
Therefore, I have made an allegation.
You may make any allegation after taking the money without repaying the same. Your conduct stops you from making such type of allegation.
There cannot be estoppel against the state.
But you first take a loan.
I have taken a loan.
You
I have
do
never
not-
said that I
you
was
do
not
not-
secured creditor.
You, as per your say, you say that you have become insolvent,
Correct.
meaning thereby the
I am
loan,
not unable to. I am unable to pay.
you are unable to pay the
Correct.
amount. Now you make allegation that the bank has lost.
Your
Their status as a
this is-
secured
now,
creditor.
Therefore I say,
No, how can there it be?
I am not blowing hot and cold. I am not blowing hot and cold. I am making a statement as per the realization made to the bank that I have been in a position to not to pay this amount. You get your amount secure. The bank has remained negligent.
So negligent, they will face consequences
That's
by
what I
separate. But that negligence, even if we believe that there was a negligence on the part of bank, it would not give any undue benefit to you.
I am not taking any benefit. I am
Yes.
not taking any benefit.
Then how can you say that we have made a specific allegation that whether now they continue as a secure creditor or not? They are secure creditor now. He is-
Therefore, my submission to insolvent court is.
There cannot be, because you file an insolvency petition, and if bank for whatever reason he remains negligent for XYZ reason, that is not the subject matter. They loses their right.
Now, now the question is there any bar that the secured creditor,
And we are concerned with only whether your insolvency petition is maintainable before the court or not. The trial court has said, no, it is not maintainable.
correct? Now, if we refer to trial court's order, whether all judgments are taken into consideration.
That would be, that I have noted. Your all judgments are not considered.
Therefore, it's not tell ultimately what will happen. It is an appeal against the judgment, which is not a judgment in the eye of law. Law says that judgment has certain characteristics. And one of the characteristics is not to even make a catalog of the judgment, cited or relied upon, but to distinguish it or to deal with it. So that is not done by the trial court. And therefore I say, Vishnu, that all these questions are required to be considered, Vishnu. And therefore, if Honorable Court considers, of course, Honorable Court may have different view, whatever. But my substantial issue is this, that bank, being a secure creditor once upon a time, would not have permanent status of being secured creditor.
If he loses the status of a permanent secure creditor, no petition of insolvency would lie against that.
No, he is a creditor.
Now, you say that there cannot be permanent status.
Permanent
as a secure
secure creditor
creditor.
status would not be there.
Not be there, as per your submission. We accept that submission.
Correct.
You say that the bank has lost his status as a secure creditor.
Correct.
Meaning thereby, you are not insolvent qua that bank.
No, I may be.
How can, once he lost the status as a secure creditor, where is the question of insolvency?
Secure creditor means he is not required to be in queue. He is not required to be in queue. Insolvency petition is a proceedings for the queue of the creditor. So he doesn't cease to be a creditor. He doesn't cease to be a creditor.
See, our contention here, it sounds very attractive and good.
No, certainly.
Once he lost a status as a secure creditor,
That means
forget the queue. Because the person who would be standing in a queue is to
Ordinary
stand,
creditor.
because he is a secure creditor. Once he lost his status as a secure creditor, as per your
Young,
submission,
young may appreciate it. There are certain privileges to certain persons. If that privileges is lost, that doesn't mean that he is not having the ordinary privilege, ordinary rights. That is what I am submitting.
so you mean to say that he has lost his status as a secure
Secure
creditor,
creditor.
but now he is as a
He is a
creditor.
creditor. I do not say no to it. I cannot say no to it. But the question is the privilege of being secure creditor is lost. That is what I am submitting.
But that, why are you bothering about that, whether he is secured or not, privilege or not?
Their application is there.
There, that other creditors, they would come and they would fight against him. Those persons have never done anything. It is your sake, these are my creditors.
Correct.
They don't want to initiate any proceeding against you. They keep on silent.
Now,
Meaning thereby,
this is also a very good point. Honorable Court now has to consider.
no,
Whether all creditors are heard.
why
That
should,
is one of the objections.
why should they be?
Therefore, you may appreciate that ultimately maintainability of the petition.
A person has to remain vigilant about their right. If they do not come and say anything, if they keep on silent,
Now, you have not there is a silence. Little bit I said this way. Silence means the notice is issued, opportunity is provided, and then he remains silent, then he has to thank himself. But the court on its own cannot say that they are not active. That is what I am submitting.
no, how, if anyone do not come to the court, then how can the
They
court?
are before the court. They are before the court.
Then
All
they-
creditors are before
then-
the court.
Then they would submit, "Okay, sir, we have more privilege than the secure creditor."
Correct, correct. You understand? Now, when they will say,
Today only two persons are here, the bank
and
and
therefore,
the so-called insolvent claim.
correct. At present, so.
Only two persons are there. So we are concerned with these two persons only.
Uh,
The material question is only one. Okay,
That would
whether
be very,
insolvent,
that would be very little bit, I say, not solvable proposition, according to me.
no, we are not leading any proposition right
The
now.
proposition in the sense that other creditors, if notice is issued or they are called upon, and if they do not object, then matter is different. But the court has never called upon them.
Why should court call them?
On the contrary, my
Unless-
application is rejected.
Yes, it is rejected, then they should,
Then the question would be, let us consider that way.
we are now, we are not bothered about the other creditors.
Okay.
We don't know whether they are creditors or not. We are only concerned with your insolvency petition.
Now you have not that, of course.
And the only question is, one is securitization, one is section 8.
Now you have not that whether they are creditor, other creditors are not, there are not. Then you have not that there must be an application of the bank that it is a collusive petition. Collusive petition. Where is that allegation? I may select certain persons being to show the creditor. Bank knows very well that they are not creditors. The bank can come out with a case that it is a collusive petition. Bank has never said so.
Bank, there was a transaction between you and
Yes,
bank.
yes, I do not say no.
The basic, when you avail the loan facility, there was a transaction between you and
Yes,
the bank
yes.
only.
Yes.
You never informed, "Okay, I have borrowed this much amount from other person also to the bank."
No,
You would never say.
I have given a list.
List is given only when you file an insolvency petition.
No, at the time of loan.
At the time of,
Loan.
you have given him a list.
Yes.
Yes,
The
to me.
time, this is my trading system. These are my creditors. I am having this book date. Loan on the book date. So certainly I am trading.
You are trading, therefore, the bank had availed the facility
Correct.
after getting your properties or goods, whatever,
What?
as a secure creditor.
Correct.
You have accepted him as a secure creditor. So they have a right to recover the amount.
They have right to recover them. Yet I stand. But the moment I am shaky, my position is otherwise, then we have to consider the legal position.
Legal position that will be between him and other person. You can say, okay, no, these are my 5 creditors to whom I have to pay this amount. So from my property, you pay to him also, you pay to him also. Your property might be worth of rupees 1 crore.
Correct.
The bank would be having, you would have availed a loan of rupees 1 crore from the bank. You would have done business with various persons, 1 lakh, 10 lakh, 15 lakhs, whatever amount. Now having 1 crore rupees property, only a person who would be having the privilege or priority as per the contract, he would have that right.
Correct.
Now, insolvency petition, no doubt, is for the for all the creditors to see that the creditors gets their amount. But the insolvent person claiming to be insolvent, he cannot have a right to say, see, now don't touch or do anything unless and until all are repaid. You might have taken you might have entered into a business transaction of 5 crore rupees with other 100%. That would be a different transaction between you and them. But the secure creditor or the first person who would be having the right over the property, he cannot be prevented from getting this property by any of the provision. There cannot be any law which
Now
would.
you may say so. Now I say this way. Why there is no provision in the Insolvency Act?
Section 8.
Section 8, Your Office.
That-
It doesn't
that-
refer to secure creditor.
That puts on that prevents there should not be a solvency petition against a corporation.
I understand. But that doesn't mean that he is required to be secure creditor.
He would be.
Therefore, otherwise there would have been bar in the insolvency proceeding itself. That no petition wherein the secure creditor can have any other right. Secure creditor is one of the part, one of the creditors. It depends upon his conduct.
But secure creditor includes creditor.
Yes, I said, no, I said, do not say no to it. Provided, and you may appreciate this, if honorable court considers other provisions also. Security Act. Section 48, 47, 48, then you have pistol case. Section 28(6), yours.
Yes, I have earlier I had noted this.
Little bit, I am just.
You would not leave.
Nothing in this section shall affect the power of any secure creditor to realize or otherwise deal with his security in the same manner as he would have been entitled to realize or deal with it if this section has not been passed. So your is not that privilege is given. That doesn't mean that a secure creditor cannot be a party in the sense that by virtue of his right, he takes away every property. Suppose your is not assume for the sake of argument. Bank is deleted, property is released. Then who would monitor the things? Who would monitor the things?
Whoever wants.
That
Bank will take action.
bank may realize at throwaway price. Bank may sell out the property. Now the question would be on whether I can represent. I have ceased to represent myself in view of the appointment of the receiver. I cannot represent myself. I have no locus now. In view of section 20 of Vishnu. I do not say that even if you take into consideration.
The bank would not invoke 28(6). He may avail his own remedy.
They may have, but they have failed. How they will get the possession of the property? Under what?
It is their concern. Neither you want to give.
I'm not authorized to give now. I'm not authorized to
You are
give
not authorized.
because I have lost my all control legally.
Then bank would realize in their own way as per their legal advice.
I do not say no to it. But the question is, my application, now I am represented by the receiver. Therefore, I say office not dead. Bank may remain.
That order is under challenge. You are represented by receiver, that order is under challenge because
Correct.
your petition has been dismissed.
My petition is not dismissed.
A bank is deleted.
Bank is
And-
ordered to be deleted.
Bank is ordered to be deleted and receiver, that is the order.
Receiver
Hand over
is
the
not a party.
possession. Receiver is directed to hand over the possession. of
So
the property.
ultimately, office not dead. If this order is to be considered legal and valid, then I have nothing to say. The order is under challenge. Therefore, we have to consider all this.
Order is under challenge.
Therefore, I say, whether the trial court has passed an order considering all these aspects. That is the issue. Order is passed, that is under challenge.
But why other issues should be considered? The court has considered section 8
Section 8, I understand.
under another section 34 and of the Surface Act and Debtors Act. That has been considered, but more is section 8. Insolvency petition would not lie against the bank. Now you say you don't have possession.
I don't.
Bank second, we have not taken any steps. Now, whether you are treated as an insolvent or not, it would be the concern of the bank how to realize the possession or property or whatever their recovery from you or whatever mode. That would be their concern.
So ultimately,
You are claiming your right to be declared as an insolvent on the basis of what bank would do, what other creditor would do.
no.
So that is not your concern.
Now, therefore, yes.
It would be their concern.
Now, therefore, your question would be, the order is passed without hearing the necessary party. Who will represent the goods ownership? Receiver is not heard. I am not required to be heard.
No, you are there.
I am there. So my submission to the Honorable Court is, I may be heard at length, or I may be heard as of right, or I may not be heard because I have no.
That is what I am saying. You are pointing out. You are arguing for your benefit that other persons are not heard. This
Correct.
is your one question. Second, how bank would realize their dues? Because you are not having possession. You say receiver is having possession. There are also certain questions about receivers now whether having control over the property or not. That are further questions. That are all concern about the bank. If they have remained negligent, his officer has remained negligent, that would be the concern of the bank and their concern officer.
Correct.
Now that cannot be a ground.
It
In your
may not be.
favor.
It may not be added.
Ah.
But the effect we have to consider.
Effect. Now effect.
Internal department, whatever they would like to, they would do. That is one thing. But the
Now-
consequence.
Suppose the bank is initiating action under Surface Act.
Correct.
As per your submission, they have not done anything till now. Then also, before that authority, you have a right. Not only you, other person, they also have a right to go before that that authority or tribunal or whatever XYZ. They can be heard
So my
to say to go and say, "Okay, sir, we are also having our right over this property." That the issue would be decided. Now, if they don't go anywhere, that means that they are not vigilant about their right.
so my
But
submission.
those creditors' right, whether they are availing or not, whether receiver is to be heard or not, whether other person are to be heard or not, that is not the issue which would tilt the balance in your favor. Because the trial court order is only on the basis of section 8. The other argument which you are raising, that would be a subsequent event in the necessity of final your petition to be decided. Here the court below has said as per section 8, insolvency petition would not lie against the corporation, that is the bank. That is the only issue. And on that basis, the order is passed.
Then other aspect is not to be taken.
Other aspect right now, neither the court below has taken into consideration.
Section 34 is correct.
34, that are all these surface act that, but that are only on the low point.
Now, therefore, I am concentrating now only on section 8.
This the court finding is that Bank of Baroda is a secure creditor. Therefore, this court has no jurisdiction to try and according to section 34. And moreover, BOB has filed a proceeding before DIT, which has jurisdiction to try and decide the relevant application. Thereafter, it is stated that according to section 8 of the Provisional Insolvency Act, no insolvency petition shall be presented against any corporation. Bank of Baroda is registered under the Banking Companies Act. An original applicant has no right to file insolvency petition against the bank of. This is the finding only. So we are
as far as 34 is concerned, court has passed an order in anticipation. We can say this way.
that I have considered. Okay. Yet
Now, as
surface
far as section 8 is concerned, section 8 is concerned, your office note. Then your office note that section 8 for that purpose, your office note that I have relied upon certain judgment. I will not repeat that good judgment, but I will only submit two things. First of all, I will say, what is the correct meaning of the appeal? The judgment rendered by the trial court will have to be tested whether it is legal or not. When the legality would be there, if the court has dealt with certain issues, section 8 issue is dealt with from the purview of the bank only. What we have submitted, that is not considered by the trial. And therefore, please note that there is a judgment. Of course, I have cited or not, I do not know. The famous judgment of Lordship M.R. Shah, Dolphin Developers. Petitioner was called upon, etc. Your Honorable High Court has held that mere noting down the submissions and thereafter passing the order without even dealing with the same cannot be said to be a speaking order.
Yes.
So therefore, I say, the Honorable Court, this Honorable Court may take the view, but that view will have to be taken into consideration by the trial court. Then the appellate court may be not have found itself handicapped that the appreciation is rightly done or not.
But that will be considered by this court.
No, I do
Your
not
submission that the
honorable-
judgments which were cited are not been considered or even touched in the order. That will be decided.
So therefore, I say, section 8 is attracted or not, that will have to be firstly decided by trial court.
The trial
And
court-
if the trial court does not decide or not dealt with, my submission to the Honorable Court is, it is a bail order in the eye of law.
Therefore, you are here.
Now, therefore, your office. Now, therefore, even if this Honorable Court comes to the conclusion that yes, this is a bail order in the eye of law, then the matter is required to be remanded to decide afresh. That is the only alternative. But this Honorable Court cannot have independent opinion in absence of the trial court opinion. That is what I am
Trial
saying.
court has opined about section 8.
Therefore, opine in absence of other authorities which I have cited. That is why I am submitting.
That we will see.
Otherwise, you know, it's not that every order, though passed by trial court, appellate court will say that yes, trial court may do whatever it likes. I am the appellate authority. I will consider independent. Ultimately, you know, it's not that.
When it is raised before this court, that issue, on one side, one issue has been raised by before this court, and thereby preventing the appellate court that no, it should not be decided. It
No,
should be
I-
decided only by the trial court.
I do
That
not say
cannot be.
that way. I do not say that.
The order passed by my Lord Justice M.R. Shah is very much clear. Okay, the impugn order, their only submission were cited and there were no reasons.
Correct.
And therefore that finding are been given. Your section 8 is considered. Your judgment.
Section 8 is considered. My
Judgment-
section is not considered.
Your
Section 8, what I have submitted, that is not considered. So ultimately, that is what I am submitting. If both the parties,
and even otherwise, appeal is a continuous proceeding. And the court can, when the issue is going to the root of the case, other issues are not required to be decided. Suppose once a jurisdiction issue has been raised, the plaintiff might be having a meritorious case. But when the court below do not have jurisdiction, then it goes without saying.
no, Your Honor. Now,
You file an application or order 7, okay, sir, you don't have jurisdiction.
therefore, Your Honor, it's not
There,
there.
so that first issue of jurisdiction is to be decided.
Correct?
And if it is raised, it is to, and it is decided before the higher court, one cannot go and say, okay, sir, my other issues are not dealt with, because that was the preliminary issue, okay, this court do not have jurisdiction.
Now, therefore, Your Honor, it's not that order 41 to 31 is there. Now, Supreme Court has taken the view that all issues will have to be answered.
Yes, certainly.
So,
All issues are to be answered when the issues are framed and there are to be decided. Your is at a first stage.
correct? It is an application.
It is not that there that entire your insolvency petition is decided. We are not at the final order of the insolvency petition. We are, an application was filed. Okay, this do not have jurisdiction. That is decided. So we will confine only for section 8 only right now. Okay, whether the trial court has committed error or not, whether it is illegality or not, and
Illegality.
whether your petition would be maintainable or not. That is the issue. That you have cited the judgment of Kerala High Court also.
No, I have almost 4 judgments.
Four judgments.
4 judgments. Wherein section 8 is elaborately discussed.
Yes. And even 28(6) also I had noted earlier that. So anything on this aspect only, section 8.
Now, the trial, in the trial court also, they have relied upon this 2009 Andhra Pradesh, page 170. Now, it's not that. Again, I will say, section 8 is considered in this judgment, along with Securitization Act. Securitization and reconstruction of the financial asset and enforcement of security interest. Provincial Insolvency Act, section 8 and 10. Enforcement of security interest. Insolvency proceeding initiated by debtor against bank, secured creditor are not maintained in view of the exemption of section or to bank under section 8 of the Provincial Insolvency Act. Therefore, any action taken thereunder would not affect action as contemplated under the provision of the Securitization Act. And in this case, it's not that security notice was given, it was served. Therefore, the court has taken this view. And therefore, I will take this honorable court to paragraph 2, or rather 3. Subsequently, on 7/6/2007, the petitioner has issued the notice purportedly under section 13(2) of the Securitization Act, which was received by the respondent number 1 on 5/6/2007. The petitioner got published in the same in the newspaper on 13/7/2007 and on 14/7/2007. However, there appears no response or any other. While on the matter stood thus, since the official is in this case, the brief account on the back, which gives right to the present proceeding. Respondent number 1 herein has filed petition purportedly under section 8 of 1928 adjudicating him as insolvent, showing that there was extent of pupillage, etc. in selected bank, etc. On 17/4/2007. So notice was issued prior to that.
Yes, I have noted that the Securitization Act, when you filed insolvency petition, there were no proceeding under the Surface Act.
No notice even.
There were no proceeding, I am saying.
Proceeding letter, but notice.
Even
was
no
also-
notice also.
Therefore, the section 34 would not come in there. Only section 8 would be
So
there.
for section 8, so now your contention, okay, only section 8, whether it applies or not. રજૂ કર્યા છે ને ફાઇલ નાખી ગોઠવી. છઠ્ઠી તારીખ 6 જૂન વેકેશન પછી 5મી એપ્રિલ છે ને છઠ્ઠી તારીખ આઈ રાખજો પછી એમ આપી દો. અને બંધ કરી દો. ઉભા રહો, ઉભા રહો.
એક મિનિટ